So first, fast-tracked evictions via repayment agreements. This is section 206 of the Act, and throughout the presentation, I kind of structure it with what happened then and what's happening now. So previously, when a tenant owed rent, the landlord and the tenant could agree to a repayment agreement. And after the landlord had served and filed their application, they could ask the board to create a consent order. And this would be an order that, was legally binding on the parties. But the order could not lead directly to an eviction, nor could it allow for what we call a Section 78 term to be included. And that's where if a tenant breaches a term of an agreement or an order, the landlord can apply to evict them without any further notice to the tenant. So then, if the tenant did breach, the landlord would have to reopen the application. However, this power was rarely used. There's only one case that's I could find publicly reported about Section 206 being used. We expect it's going to be used a whole lot more now, because now these agreements can include a Section 78 clause. And so that will allow the landlord to file for an eviction without notice to the tenant if the tenant breaches the consent order. Some caveats to that: if the tenant feels like they've been unduly pressured or misled into agreeing, they can apply to reopen the application within 30 days of the consent order being issued. A challenge with that is that that means that they're basically saying, I don't like this consent order at all, I'd rather go to a hearing, and it will recreate or reschedule a hearing that would have happened sooner probably than if they had successfully paid off their consent order repayment plan. If they do breach, or if the landlord thinks they've breached and files for an eviction, tenants have only 10 days after the eviction order is issued to file for a set-aside, which is basically saying, yes, I breached, but I should still be allowed to continue the agreement because I've made good, or no, I never breached, the landlord has been dishonest. My concerns regarding fast-tracked evictions are that landlords control the timing of when to file and serve documents in the eviction process. And as a result, they have a lot of power in that process. And tenants are scared of dealing with their landlords during this process. They want to make things right. And they may not understand how or what their rights are. And we can't trust, unfortunately, that landlords will give tenants good information or referrals. Probably some will, but many won't. And that will lead tenants to make optimistic agreements with their landlords that they think, they're agreeing to what they think the landlord wants to hear without really thinking about whether it will be an agreement that they can live up to. They just want to, buy themselves more time. But there may be good legal reasons for why the tenant wasn't paying their rent or wasn't paying their full rent. And tenants are often unaware of the programs and resources that can help them. There's the legal clinic, there's YSSN, there is, the rent banks that we have in York Region. And finally, 10 days is very little time for tenants to receive an order, generally in the mail, find the legal clinic, and get a motion to set aside filed. So when Josie was speaking, this is what we're concerned about will really speed up the issuing of eviction orders.